Thank you, Mr. Chairman. I think it's clear that both there are liberal groups or conservative groups that both follow the law, follow the regulations as they exist today. But there was only one group that was targeted. And you all can get here and say that there wasn't political targeting, but it just doesn't comport with the facts. Maybe it wasn't you, but somebody was. And I think one of the purposes of this hearing is to find out who was targeting conservative groups. Otherwise, you can't explain the fact that you had all these conservative, whether it was Patriot or Tea Party or 912 in their name, selected for extra scrutiny. You had no evidence that there were groups with progressive or names like that that were similarly targeted. I mean, I think it's just, let's put this issue to rest. There's political targeting here. I don't think there's any way you can deny that. I'm interested in knowing, Mr. Miller and Mr. Shulman, if either of you were aware that Ms. Lerner was going to plant that question and try and get ahead of the news cycle by disclosing this prior to the release of the IG report.
I think I mentioned that I did know, yes.
Okay, and were there any discussions, the reporting is that the White House was aware, the White House counsel's office was aware on April 24th of this information. Were there any discussions with the White House about Ms. Lerner's intention to drop this bomb at the ABA conference?
I had no conversations with the White House, sir.
Are you aware of anybody else that did?
I am not aware of that.
There's also been reporting that Deputy Secretary Neil Wolin and Treasury General Counsel were made aware of the IRS or the IG report looking into the targeting of groups last June. Did you have any discussions with Treasury around that time?
That's a question to me, sir?
You or Mr. Shulman? I guess you'd probably be the...
I was deputy at that point, but no, I did not have any conversations at that time.
Mr. Shulman?
I don't remember having any conversations with the Treasury Department.
Okay, so there are no discussions. Are you aware of anybody that had discussions with the Treasury Department? The Treasury Department became aware of this information way back last June. None of that was, there were no discussions between the IRS and the Treasury that you're aware of.
Let me clarify. I think everybody knew that it was very difficult to administer the C4 laws. And so I don't have any memory of it, but there very well could have been conversations about policy, the policy matters that members of this committee have talked about. Should the primary purpose test be changed? At least standing for me, there were no conversations that I had with the Treasury Department about the matters in the report relating to inappropriate criteria, you know, all the things that were in the news.
And that's the answer that I was giving, sir, just to be clear.
Okay. Now, Mr. Shulman, you testified in front of the House in March of last year that there was no targeting. You became aware of that in May. Don't you think that you should have had an obligation to clarify or to correct that statement that you'd made in front of the House committee?
In the spring, when I found out about a list that was being used to help place these applications into the determinations unit, what I knew was there was a list. I did know that Tea Party was on it. I didn't know what else was on the list. I had a partial set of facts, and I knew that the Inspector General was going to be looking into it, and I knew that it was being stopped. And sitting there then, sitting here today, I think I made the right decision, which is to let the Inspector General get to the bottom of it, chase down all the facts, and then make his findings public.
Let me ask if I could, Mr. George, you mentioned earlier that disclosure of confidential information would be a violation of law?
It is, but whether it is administrative or criminal is the issue. But yes, it could be a violation of the law, specifically Title 26, Section 6103, and or the Restructuring and Reform Act of 1998.
And so the reporting about the giving of this information to ProPublica, release of confidential information, could very well be a violation of law.
It could be. It could have been, rather, I should say.
And let me just ask all of you, because there was a statement made over the weekend by somebody from the White House that the law would be irrelevant. Do you believe that the law is irrelevant, or is it relevant to this?
I believe the law is always relevant, sir.
Right. Gentlemen?
I'm not sorry. I'm sure I understand your question.
Well, there was a statement made over the weekend that whether the laws were broken was irrelevant. I'm just asking, do you believe that the laws are relevant in this case?
I mean, I guess I would agree with
I think the answer-
Inspector General that
Yeah.
people should not break the law.
The answer would be yes. Well, Mr. Chairman, I just think there are a couple issues here. One is the targeting issue, and clearly that has, to me, a lot of political overtones. The other one is if there's information that was disclosed, that would be a violation of law. It's a very serious matter. But I think the American people believe that this is a very serious matter for both those reasons. They believe that the laws ought to be followed, and I think they also believe that they ought to have an IRS that competently conducts its business in an objective, fair, and transparent way. And those are all things that are missing in the equation. And so I hope that we continue to get more facts out about this, and that the corrective actions are taken. Thank you, Mr. Chairman.